Hello and welcome back. I'm Chris from jdlogic.org, and this is How to Write a Law School Memo, Part 2. In the Part 1 video, we went over a few things to get started. One was reading the prompt, the second was starting your legal research, and the third was organizing your legal research. A quick note on research: since that video came out, Lexis has actually come out with their own AI companion, which makes that initial search much easier. So you can just search in like plain language terms now. You could just ask the search, what does provocation mean for a dog bite case in Illinois? So that initial phase got much easier. You can just ask simple questions, but you still need to go in and find the cases. So it will suggest some cases to you. And once you get to that point, the process is going to look the same. You're going to have to go into the cases, read them, understand the facts of those cases, and understand what rules they're trying to convey. If you haven't watched the first part of the video, I would recommend that you go do that. But just to get you back up to speed, our situation is that a woman came into the office. She says her son has been bitten by a dog, and she wants to explore her options to sue the owner of the dog. And really, our basic legal question here is if the boy provoked the dog or not. So if the boy provoked the dog, then the mother's likely not going to be able to recover. But if the boy did not provoke the dog, she might be able to recover. So that's where we're at right now. We've already done some research. We have our cases organized, and we're going to move on to the next step, which is outlining. But before we start actually putting anything on paper, I just want to quickly explain the structure that we use in legal writing. So there are two different structures that you'll most likely be exposed to in law school. One is called IRAC, I-R-A-C, and one is called CREAC, C-R-E-A-C. IRAC stands for Issue, Rule, Analysis or Application, and Conclusion. CREAC stands for Conclusion, Rule, Explanation, Application, and Conclusion. So they're very similar. Mostly you'll be using IRAC in your doctrinal classes, like a torts class, a contracts class, is to do your legal analysis and answer questions, hypotheticals in class and on the tests. But for a memo, it's a little more formulaic, and we're going to use CREAC. So for our memo, we're going to use CREAC. And the big difference really is the E section, which is the explanation section. And in our case, and in most of your cases, the E section is going to be case illustrations. In fact, some schools even use CRIAC and just call the middle section illustration. But it's important for you to understand how the CREAC structure works, because we're going to lay out our outline as a CREAC, and then we're going to convert our outline into our draft. Before we get too deep into the CREAC and the outline, we need to understand how that fits into the greater scope of the whole memo. So your memos may be different, and you're going to have to look at the instructions and see what elements need to be submitted as part of your assignment. But generally, there are 6 components of the memo here, and let's go through them first, just so we can situate ourselves. So the first area up here is our heading. So this is pretty straightforward, not a whole lot to learn on that. But the next section of the memo is usually the question presented. Now, if you remember, we just talked about IRAC and the issue. So this is kind of where our issue is stated. And you're going to learn a specific way to write these questions, but you're basically laying out the issue for the reader. The third section is called the brief answer. And the brief answer is a really short version of what your whole paper is about. So if somebody was just reading this paper and they just wanted to know what your answer was and what your main argument was, they could just read the brief answer instead of reading the whole memo. The third section is the statement of facts. So before we make our legal arguments, we need to tell the reader everything that happened. So we, in the last video, we looked at the whole assignment and we looked at all the facts that happened, what happened between these boys and the dog and the owner of the dog. And you're going to write that in a specific way as well. And you'll see that is usually a couple pages depending on what your professor asks for. But then the big section is the discussion section. So when we talk about doing a CREAC for a legal memo, what we're really talking about is doing the CREAC for the discussion section. So this is the big one. This is the one that you have to be really worried about. And this is the one that's going to be a new type of writing for most people watching this. So that's what we'll spend most of our time talking about in this video, is going through that discussion section, how to formulate the CREAC for that, and how to make our legal arguments. So you'll see the discussion is the biggest piece here, and then finally the conclusion, which is just a wrap up, again, sort of like a review of our arguments. Okay, just to help you visualize this a little bit and think about how we're going to organize this outline. Here's our 6 sections that we just talked about that are going to end up in our final memo. So one thing that we always want to be thinking about is the issue. What is the question presented that we need to be answering? because that's going to help guide us towards all of our research and all of our organization. And the other big section, as I said, is the discussion section. Now again, the brief answer and the conclusion are kind of just summarizations of the discussion section. The statement of facts is its own thing. That's just the facts of the case. So that's not really your legal analysis. So what we're going to do for our outline is we're just going to stick to the question presented and the discussion. And I'll show you how I have that set up in a second here. Okay, so this is how we're going to set up our document to start outlining. So as I said, we're going to start with our issue. And then you see we have CREAC here. C-R-E-A-C. Now, for my purposes, when we go to write, we're going to need to put this C back in. But I'm just trying to get my thoughts organized here, and I don't need two versions of the conclusion. So I'm just going to get rid of that for now. And we're going to end up with a document that just has our issue, the rules that we're going to use, the explanation, the application of those rules to our facts, and then our final conclusion answering the question. Okay, so let's start filling in some of the information that we already know. So if you watch the first video, you know what the case is about. We're just going to put in, here is the issue we're trying to answer. So we have Kenny and Wade are two little boys. They were at the park. They see a dog. They start kind of messing with the dog, doing different things to the dog. And our issue here is, does that equal provocation? In this case, provocation is what we call a term of art or a technical term. And we need to know what the state of Illinois says provocation is in this situation. So here's our issue. Did Kenny and Wade provoke Dingo, Dingo is the name of the dog, when they barked and shouted at Dingo, threw sticks towards Dingo, ran towards Dingo close to his perimeter, and Kenny reached into Dingo's dog bowl? So that's actually a pretty developed, that looks something more like the question presented. But if you just wanted to start with, did Kenny and Wade provoke Dingo, that's just as good. Just so we know what we're looking for. So the next section up is our rules section, and this is a very important section. So we need to list all of the rules that we think are pertinent to understanding this question. What does it mean to provoke a dog in this situation? So now we just have a blank page, but if you remember from the last video, we already did a lot of this work. So let's take a look at this document. This is a document that we created last time as part of our research. This was our final step. Last time was taking the cases, reading them, and narrowing them down into what the most important things are. And if you remember, here we have our citation for the cases. Here we have the facts of what happened in each case. The holding, which is what did the court decide in this issue, provocation. So in that case, was the dog provoked or not? And then our important section over here was our rules of rationale. So now we're starting to think about the rules that we want to use in our paper and what we want to put into the outline. And we have all of these rules to choose from these 5 cases that we read, and from the statute originally telling us what provocation means. So that's what we're going to do. We're going to take the rules out of here, and we're going to put them into our outline, and then we'll start thinking about how the rules kind of all work together, and I'll show you that in a second here. Okay, so we've taken our rules from our research document out of the cases, and we're going to drop them into this outline here. So I've included a bunch of rules, so you have a lot of rules to work with, and some of them are kind of redundant. But you see up here I have the concept of broad to specific. So what we want to do is start with the broadest understanding of what, in our case, provocation means. We don't know what that means at this point. Now we're going to narrow it down to more and more specific instances of provocation existing or not existing in our cases. Ultimately, we're going to use all of that information and all of these other cases to synthesize our own rule, make up our own rule. And that's a piece that's often most uncomfortable for students. But let's kind of look at what we have here as far as rules go. So we know right off the top that you can't recover if the dog was provoked. Well, that gives us our question of what is provocation? And then you have rules that come out of the case that you go, this isn't very helpful. Provocation is defined as an act or process of provoking. Okay, we still don't really know what that means. But let's go down here and look at this rule out of the Stell case. It says the question of what conduct constitutes provocation is primarily a question of whether the plaintiff's actions would be provocative to the dog. So what the Stell case is telling us is that eventually what we need to look at is what happened between the plaintiff and the dog. What were the plaintiff's actions towards the dog? And then we ask whether or not a dog would respond the way that they responded. And if the dog responds like a normal dog, up here we have a couple of issues of a reasonable dog. Thus, we need to look at the plaintiff's actions and ask whether or not a reasonable dog would be provoked. So what we're ultimately going to do, and we're going to do it down in the E section specifically, but we want to look at these other cases and say, well, what sort of conduct are we looking for? What sort of actions between the plaintiff and the dog constitute provocation? And because we did that research and we have a research chart, we can simplify it down to really simple statements here. For instance, we know that stepping on a dog's tail is provocation. A normal dog would bite somebody if they got their tail stepped on. But screaming alone is not provocation. Kicking and pushing a dog is provocation. And then we have this one that's a little vague, but entering a dog's perimeter with food present could be provocation. So we're going to whip these all into a synthesized rule, and we're going to try to come up with a way to compare our facts from Kenny and Dingo to the facts from these previous cases. But you see how that works from the broadest to we're looking for provocation. What does provocation mean? Well, we don't really know. We're going to look at what happened between the dog and the person. Well, what are some examples? Well, now we have some specific examples here of things that are and are not provocation. Okay, so we've pulled a bunch of rules out of the cases and we've tried to understand what the cases mean, but now it's time to synthesize our own rules. So we have all this stuff going on, but we need a simple way to explain it to whoever's going to be reading this. This is a part that really intimidates a lot of students, and it can take a lot of time. So there is no really one correct answer. What your job is to be this filter. And this is what lawyers do, and they come up with their own rule to help explain how the precedent and the law applies to the people involved in this case. So what I've done is I've looked at all this stuff, we've looked at all these cases, and we've tried to articulate how do we know if it's provocation. And what we've come up with is this synthesized rule. The more physical contact or physical threat between the victim and the dog, the more likely a reasonable dog would attack and provocation will be established. So up here we're learning, hey, we got to look at what happened between the dog and the person to decide if it's provocation or not. And now we're saying, okay, let's lay out a rule. If it's more physical and maybe violent, that's more like provocation. And if it's not physical, maybe something just like talking to the dog or yelling at the dog, that's less likely to be provocation. So that's our synthesized rule, and that's where we're going to stop talking about rules for now, and we're going to move on to the next step. So we're going to move on from our R section to our E section. Now we're going to talk about how to format a case illustration. Okay, so we are within our E section, the explanation. We're trying to explain what the rule means. We're going to do that via a case illustration. So each case illustration is normally one paragraph. You're going to devote that entire paragraph to one case. There are certain pieces that are normally included in a case illustration. So the first piece is called the hook. And the hook is probably the least consistent one across different law schools and different professors. But to me, the point is to hook the reader in and tell them, why did you choose the case that you chose? So for instance, one of the cases that I chose is called Robinson. Robinson is the case where a kid screams at a dog and the dog bites them. And the court says that that's not provocation. Screaming at a dog is a reasonable response is not to bite for a dog. So in our hook, we're going to say, hey, Robinson is a case that talks about screaming not being a provocation. So the reader goes, oh, okay, tell me more about that Robinson case. But different professors want it done differently. Some want you to kind of restate a rule, like screaming alone is not provocation, and then jump into your facts. You have to work with your professor on that and pay attention to what they're asking for there. But the rest is pretty standard. So we need the facts. We're going to tell the story of what happened in the case. The person did this thing, the dog responded in this way, there were these injuries, so on and so forth. Third thing that you need is called the holding. So the holding, as we did in our research chart, is answering the question, what did the court say in that case? So did the court say that the dog was provoked or that the dog was not provoked in that case? And then very importantly is the rationale. So the court in your cases is going to explain why they think, for instance, screaming is not provocation, whereas maybe something else would be provocation. And that becomes very important when you start comparing your facts. So what did Kenny and Wade do compared to the facts of the people in Robinson? So we need to understand why the court argued what they argued or held what they held so that we can compare that logic to the logic that we're looking for in our case. Okay, so going back to our outline here, what I've done is I've decided, I think earlier I said I only did 2 case illustrations, but I actually did 3. I decided which cases I wanted to use. So the ones that I thought would help me best explain the rule and talk about what Kenny and Wade did. So for my outline, I did not do all those those pieces, and I'm going to show you how to actually write them when we move on to drafting after this. But for now, I've just put the 3 cases that I decided. Again, you can do this however you want. A quick note on outlining, though: the more detailed you make this document, the easier it's going to be when you start drafting. So one of the tough things about drafting is you're sitting there with a completely blank page, and it's hard to get started. So for instance, if you went and you already did your hook, facts, holding, and rationale for each of these cases, then when you get to your explanation paragraphs, your case illustration paragraphs, you could literally almost copy and paste it and reformat it, and you have that section done right. But for now, in the interest of time, I'm just going to show you how to do each of these sections once. I'm going to wait until we get into our drafting section. Okay, so we're in our CREAC, C-R-E-A-C. The A is application. So we have these rules. We have some examples that we can compare to. And then finally, we want to apply those rules to our case with Kenny and Dingo. So you'll notice up here, when we write these sections, that our rules are not about Kenny and Dingo. They're about abstract concepts. Our explanations are about specific examples, but they're not Kenny and Wade. We're only talking about the cases up here in our explanation. So the application is when we're going to have all of that stuff come together, and we're going to start talking about what happened with Kenny and Dingo as compared to these other cases, and apply our rules. So here for my application section, I'm going to keep it kind of light. And all I've said so far is that when we start applying this, we say, well, screaming, we know, is probably not provocation. But I think that a combination of physically threatening Dingo, entering his perimeter, and his food bowl will probably amount to provocation. And applying our broader rule is a reasonable dog in that circumstance, with all the things that the boys did to the dog, is probably going to attack. So I think it is provocation. And how we're going to do that, how we're going to explain that, is we're going to compare to the 3 cases that we illustrated above. So I just have here how I think Kenny's facts compare to the facts in those other cases. This one talking about screaming. This one was talking about hitting the dog, which they didn't do, but they did kind of physically threaten him. And then this case was about a guy that went into a dog's territory and there was food there. So that's going to compare nicely to what happened with Kenny and Wade too. So we'll get more into how all those pieces work when we get to the drafting section. But for now, we're just kind of trying to understand what is our analysis. What do we think the outcome is in this case? And then finally, our last piece of the CREAC is the final C, which is the conclusion, which is where we're just trying to answer the question. So if we look at our analysis section there and we try to answer the question, I think that the combination of behavior, especially physically threatening, entering the perimeter, reaching the food bowl, would likely establish that Kenny provoked Dingo. So our conclusion, we're trying to answer the question. Our issue, remember, all the way at the top was, did Kenny and Wade provoke Dingo? And our answer, I think, is going to be yes, they did provoke him in that situation. So that does it for our outline. Like I said, the more detailed the outline is, the easier it's going to be to start writing. But we have all of our thoughts in one place. We have it all organized. We know what our CREAC is going to be within our discussion section. And at that point, we're ready to move on to the next step. Okay, so we got our outline done, and it's time to start actually drafting this thing. This means putting it into the final format as you'll submit it for your class. So what I've done here is remember the first thing we talked about is you're going to have a caption. Your professor should give you an example or actually a template that says what they want in that situation. So it's going to be different depending on what they ask for. But what I've gone ahead and done here is labeled our big headings for the 5 other main pieces of the memo that we're going to need. Those being the question presented, the brief answer, the statement of facts, and the conclusion. Similar to our outline, we need to think about the order here. So the question presented, maybe you could do first, but the brief answer and the conclusion, you have to wait until you've written your discussion, because they're based on your discussion. They are summaries of your main argument in your discussion. So we can't do those. We're not going to be able to do these things in order. And the statement of facts, as I said, is kind of its own separate thing where you're telling the story of everything that happened. So we're going to start with the question presented, and I'll show you the technique that's typically used for that, the format that's used for that. And then we'll jump into the discussion. As we said, that's where our big CREAC is, and that's where things get kind of hairy. Okay, so this is what our question presented looks like. Under Illinois statutory and common law, which allows animal attack victims to recover when the animal is not provoked, is provocation established when the victim yelled at, lunged toward, threw sticks at, and reached into the food bowl of a dog. So this is another one that's not all that consistent, but in the book of Where Rights, which I really like, they kind of talk about, you have this kind of under, did or is, and then when sort of setup. So you're gonna have to, again, pay attention to what your professor's looking for. But the general concept is we're explaining what type of law, what body of law we're applying, and then we're describing a little bit about that law. And then we want to include some facts that actually happened in our case. So in our case, Kenny yelled at the dog, lunged at the dog, threw a stick at the dog, and eventually reached into his dog bowl. So it's really up to what your professor's looking for there. What's not gonna work is just saying, did Kenny provoke the dog? They're going to expect some sort of statement of the law and then some facts from your case to be within that question presented. Okay, so that's our question presented. It's normally worth not that many points. You're just gonna have to play around with it and write 3 of them and submit them to your professor or your writing fellow and see which one they like better. But pretty straightforward. We're just trying to identify the issue, and we're just trying to work some of our facts and law into that statement of the issue. So, like I said, our next step is going to be to go to the discussion rather than try to go in order. So this is where we're going to have our big CREAC here. And in our case, I don't want to confuse you, but I did 3 case illustrations. So ours is really going to be like a CREAC, and I'll show you in a second here how we're going to format that. Okay, so when you start your discussion section, you're not going to jump right in to the CREAC necessarily. You're going to have something called an umbrella section or a roadmap section. These are introductory sections where you have to assume that the reader of this is not an expert in dog bite law, Illinois law, tort law, anything. So we need to build them a roadmap, again, from broad to specific, giving them context for why we're going to talk so much about provocation in the rest of the discussion. So let's go through this sample sort of umbrella section, and you'll see why it's necessary. We don't just want to jump right in and start saying it's provocation, it's not provocation. We need to give the reader some context so that they understand kind of where this whole thing is situated. So what we have is Mrs. Power's ability to establish liability for Dingo's owner is governed by Illinois statute, the Illinois Animal Control Act. So we're going as broad as possible. Why can anyone ever recover in Illinois for a dog bite? It's because of that statute. The statute states that if a dog without provocation attacks, attempts to attack, or injures any person, the owner of such dog is liable in civil damages to such person. And you see that we cited there to the statute. We'll talk about citations all the way at the end, and I'll show you an example of how citations are normally done. The following 4 elements must be proven. So these elements are just a recitation of what is in the statute here, but they're just a little bit easier. We need an injury caused by an animal owned or harbored by the defendant, lack of provocation, peaceful conduct of the person injured, and presence of the person injured in a place where they have a legal right to be. So again, we're just starting as broad as possible and saying here's what our client will need to prove all 4 of those. But if we remember what our boss asked us way back when we started this thing, that we're only supposed to talk about provocation. So we want to let the reader know that. So we have here, this memo only explores the topic of provocation. If a court is to find that Kenny and Wade provoked Dingo, Mrs. Powers will likely be barred from asserting liability upon Dingo's owner for the damages caused by the attack. So we're just helping the reader understand what we're talking about. So that's normally referred to as an umbrella section or a roadmap section. They can take very different forms, especially as your memos get more complicated and with multiple issues. You may be previewing, hey, we're going to talk about 1, 2, 3 issues. Here's what I think the answer is on question 1, question 2, and question 3. So you should cover more of that in your class, but we want to move on to the CREAC is the big section here. Okay, so we got that umbrella section in there, explaining kind of where we're going, and now it's finally time to start writing the CREAC. So this is how you're going to lay out your paragraphs. So typically the first C and the R are in the first paragraph. Then each explanation, each case illustration is going to be its own paragraph. And then at the end, depending on how you want to format it, you could have 1 paragraph per case, but I just combined all of mine into 1 analysis, 1 application section. And then you can put the conclusion in that same analysis paragraph because it's only it's only going to be one sentence. So let's look at our first paragraph here. So this is our first C here, and then we're going to go into the rules here. Let's just highlight these so we can follow them easily. Okay, so our first one is a conclusion. A conclusion is answering the question. Our question is, did he provoke the dog? And we say, our conclusion is, a court would likely find that Kenny provoked Dingo. So that's all we're doing. We're just answering the question as it was posed to us, and that's our conclusion. From our outline, that's what we decided, is that it looks like Kenny and Wade did provoke this dog. Okay, now we're going to set up the rules. So you see my rule section here is 1 sentence, 2 sentences, and 3 sentences. So let's take a look at what we wrote here. When the case does not involve a dog known to be vicious, provocation means any action or activity, whether intentional or intentional, which would be reasonably expected to cause a normal dog in similar circumstances to reasonably react in a manner similar to that shown by the evidence. And that came out of the Kirkham v. Will case. So this is a direct rule directly from a case. So I felt like that case explained really well what provocation is in a broad sense. But then we learned in another case, or from that same case, that this is a case-by-case analysis that requires the court to ask from the dog's perspective how an average dog would respond to the actions of the victim. And then we had our rule that we discussed is our big synthesized rule, is the more physical contact, threat conveyed, or imposition into the dog's space by the victim, the more likely the dog's response will be reasonable, and the more likely provocation will be established. So we've taken these rules from broad to specific, and we've ended up with something that looks very similar to the rule that we synthesized in our outline. Again, this is it's a big process, and you're going to want to go back to your outline multiple times and try to understand what's the best way to explain this concept to the reader. But remember, the point is to lay out a rule and then use some cases to explain what that rule means. So what we're going to do is move on to the first E section. So remember, we're looking for the hook, the facts, the holding, and the rationale. Okay, so let's start with the hook. Like I said, the hook is not the same for every class, but for me, the point is to introduce the case and tell the reader why we're going to talk about this case. So what I have is, in Robinson v. Meadows, the Illinois Court of Appeals held that a dog attack in response to a child's scream was not reasonable, and thus the child's scream was not provocation. So you're telling the reader, I have this important case, and here's why I'm bringing it to you. It's a case that found that there was not provocation, and not provocation in response to screaming. So we're going to learn more about what happened in that case as we keep going here. Okay, so after we've written the hook and we've told the reader why we're talking about this case, why we think it's important, we need to lay out the story of the case. So here we have, this is a very simple version of what happened in the case. In Robinson, a knock at the door caused 2 dogs to begin barking. The barking startled a young girl, nearly 4 years old, causing her to scream. In response to the scream, one of the dogs viciously attacked the girl, causing injuries to her face and neck. Very simple recitation of the facts. Again, depending on how complicated your cases, you may need more or less, but normally, 2 or 3 sentences about the facts is normally sufficient to help the reader understand what happened in the case. Okay, so like we said, after the hook, facts, we need the holding. The holding is what did the court decide, and we need the rationale. Here, I combine them into one sentence, which may or may not be the case, just depending on how your memo comes together. But let's look at what the holding says. The court held that while the dog's attack was certainly in response to the girl's scream, the scream did not provoke the attack. So we want to know what the court decided on provocation. They said this is not provocation. And then I went ahead and put in the rationale as part of the same sentence. Because the dog's response was not reasonable, an average dog would not respond to a scream by attacking in the same manner. So that brings us right back up to our initial rule, which is a dog has to respond in a reasonable manner. If the dog responds reasonably, then it's provocation. And now we have one specific example from this case. Okay, so what I've done now is remove those labels, and we just have this nice paragraph about Robinson, which tells us that screaming alone is not provocation. So I just want to go ahead and read the other case illustrations so we can see that format repeated again, and so that you have the information so you can understand the analysis section that's to come. So in Seaworth v. Charleston, provocation was found when the victim physically attacked a dog. That's my hook, telling us why we're talking about this. It's a case in which provocation was shown. Now we're going to move on to the facts. In Seaworth, 2 boys admitted to kicking and pushing a dog while they were playing on a porch. After the boys kicked and pushed the dog growled and bit one of the boys on the head after a delay of roughly 2 minutes. The court held that pushing and kicking of a dog is precisely the type of provocation that the legislature envisioned when writing the statute. The intent was to bar from recovery those victims of dog bites, those who invite the attack by prodding the dog. In making its ruling, the court held that the court's response was reasonable given the circumstances, and thus the victim was provoked. So we have the holding. The court held that kicking and pushing is provocation, and then it tells us why, kind of 2 reasons. One is that that's exactly what we're talking about. You're not going to be able to recover if you go kick a dog and it bites you. That's not the owner's fault. And then also coming back to our reasonableness of, as we're talking about in a case where a dog is kicked, it's reasonable for that dog to bite. And then we have another one. This is another E. This is Stell v. Dose. And here's my hook here. Stell v. Dose is another case in which the Illinois Court of Appeals found that the facts supported a finding of provocation. In Stell, a man was attacked by a dog after entering the dog's perimeter while the dog was eating. The man was supposed to retrieve the dog from a farm where the dog was tied up with a 25-foot chain. The man entered the perimeter of the dog's chain and gave the dog food. While still in the perimeter and while the dog was eating, the man turned his head and the dog attacked by biting the man's forearm, causing serious injury. So here's all of our facts, telling the story of what happened in Stell. The court held that these facts supported a finding that the dog's response was reasonable and that the man had provoked the dog by occupying the dog's territory with food present. So our holding is that that is provocation, and that the reason it's provocation is because you've entered the territory of the dog and messed with the dog's food. So that response was reasonable in this case. So that's what our E section looks like, all written up. We have 3 different E's here, which hopefully isn't that confusing, but you should be able to see the format each time. We're introducing the case with a hook. We're giving you the facts of each case, and we're telling you what the court decided, the holding, and why they decided that. All right, so we've done our first C, which was our conclusion that we think that Kenny provoked the dog. Then we laid out our rules. Then we've given 3 different E's, 3 different explanations, case illustrations that tell us different instances of people being attacked by dogs and whether or not they were provoked. Now, in our CREAC, we're going to move on to the A, and the A is the application. So this is where we're going to start talking about Kenny's actions. So there are different ways to do this. Like I said earlier, if you have 3 E paragraphs, you could do 3 A paragraphs. I decided to put them all together and compare Kenny's actions to each of the acts of the previous cases. Okay, so let's have a look at this, and we'll talk about how you compare your facts to the facts of previous cases, and you want to weave them together and really compare what happened so that the conclusion that you're coming up with is logical with the logic of the previous courts. So I've said each of Kenny's actions towards Dingo must be considered to make a determination about provocation. Here, Kenny's acts of screaming and barking at Dingo will probably not alone rise to the level of provocation. So we're coming to a conclusion there just on the screaming action. And what we're going to do now is compare that screaming action to a screaming action that we saw in a previous case, which was the Robinson case. So here we have the victim in Robinson simply screamed, which caused the dog to bite her, but the court found a lack of provocation in that a bite response was not a reasonable response based on the scream alone. So again, we're going to try to apply the same logic of Robinson. So that's what we say here. Applying the same logic as the Robinson court, Kenny's screaming and barking are likely not provocation. Now we're going to move on to Kenny's other acts. Kenny's acts of throwing sticks and lunging towards Dingo are more likely to be the basis of provocation. Again, we're going to want to start comparing to a case and weaving our facts in with the facts of the previous case. While Kenny's actions did not result in actual physical harm or even contact with Dingo, which distinguishes his actions from the boys in Seaworth who kicked and pushed a dog. You see how we're mixing the facts completely together. We want to talk about the facts of Kenny and Dingo, and we want to talk about the facts of what happened in the previous case. A court would likely find that Kenny's acts of physically threatening Dingo would incite a bite response from a reasonable dog. And then finally, Kenny's act of entering Dingo's physical perimeter and reaching into his dog bowl likely established provocation. similar to the victim in Stell. And we're going to reference some specific facts in Stell, who was attacked when he physically entered a dog's perimeter while it was eating. A court would likely find that Kenny's act of entering Dingo's space and reaching into his food bowl would incite a bite response from a reasonable dog. So that's our A section. We are trying to compare all the logic and facts from the previous cases that we discussed in our E section with the facts that we know about Kenny and Dingo in this case. So now that we've done all of that application and we've compared to these other cases, we just need to finish our CREAC with our final C, which is a restatement of our final conclusion here that we think Kenny probably provoked Dingo. So we just have the combination of Kenny's physically threatening Dingo, entering his space and reaching into his food bowl would likely be deemed provocation in Illinois. All right, so that's the basics of how this CREAC format works within our discussion section here. So I know I went quickly and made it seem very simple, but as long as you sort of understand the format that we need to tell our initial conclusion, what we think the answer is, then we need to tell all of our rules, then we need to discuss all the cases that we want to compare to, give each of them their own paragraph, and then put it all together by applying and comparing our facts to the facts of those cases, and then rounding it off with a restatement of the conclusion with some reasoning behind it. As long as you understand the basic format, you can apply it to different types of questions in your discussion section here. All right, so we finished up the discussion section, which is the biggest hurdle here. It's the big part. That's where our big CREAC is. And from here, it's just kind of putting together the additional 3 sections of the paper that we need to write. Like I said earlier, the brief answer is kind of a simple summary of what we said in our discussion section. So let's take a look at how that normally looks and show you the example here. Okay, so here's our sample brief answer. You're always going to start with yes, no, likely yes, likely no. Those are the most common ways. So we're answering this question. So the question was, all the things that Kenny did with the dog, is that provocation? And our answer is likely yes. The court would likely find the actions of the victim will constitute provocation in this case. And then we're going to get a Cliff Notes version of our discussion section. So under Illinois common law, provocation is established when the acts of the victim are such that a reasonable dog would respond to acts with proportionate force. Under Illinois statutory law, a victim is barred from recovering if provocation is present. As is the case here, where Kenny yelled at, lunged toward, threw sticks at, and reached into the food bowl of a dog, provocation will likely be established. Thus, the victim will likely be precluded from recovering for the damages caused by the dog bite. So that's all there is to it, really. Again, if you have more complex, a bunch of it, let's say you have a 3-issue paper, you might want to do your brief answer. Yes, I think this person will be liable. On question 1, here's my answer and why. On question 2, here's my answer why. On question 3, here's my answer and why. But we have a simpler, just a 1-issue paper here, so it's quite simple. All right, like the brief answer, the conclusion all the way at the end is just a recitation, really, of what you talked about in the discussion section. So let's just roll down to the conclusion, and I've already put it in there. Mrs. Jennifer Power will likely not be able to establish that her son, Kenny Power, was attacked by Dingo, the dog, without provocation. If a jury considered Kenny's actions, yelling, throwing sticks, lunging at Dingo, entering Dingo's perimeter, and reaching into Dingo's food bowl, in their totality, they are likely to find that Kenny's actions constitute provocation. If a jury were to find provocation, the Powers will be precluded from recovering for Kenny's injuries under the Illinois Animal Control Act and common law precedent regarding liability for animal attacks. Because provocation is likely present, I recommend that we do not file a claim under the Illinois Animal Control Act. If we are going to continue with Ms. Power's claim against Dingo's owner, I recommend we pursue a different theory of negligence. So part of this, though, is we've sort of rephrased what we said in our discussion, but we also need to think about, when we go back all the way, remember this circular process, if we go all the way back to what our prompt was asking for, it was our boss asking us to make a prediction about provocation. And so we're responding to that request as well. So that's the conclusion. Pretty straightforward once you have the discussion figured out. All right, so the last thing that we need to do is the statement of facts, which is telling the story of everything that happened between the boys and the dog. I'm not saying you should necessarily do the statement of facts last. Actually, if you're having trouble getting started and you feel like you're not making any progress, it might be good to do the statement of facts earlier on and feel like you're getting some words on the page so that you feel you're making progress. So the statement of facts is pretty straightforward. You're telling all the important things that happened, trying to leave out things that aren't important. But a couple of comments about the statement of facts is that my statement of facts does not have any citations. So if you remember back to the very beginning in the first video, all of our facts came out of a memo that was written to us by our boss. But oftentimes what you'll be given is a series of documents. Maybe it's depositions or other bits of evidence, emails or photos or something like that. And you might be asked to cite to the record or cite to those various documents. So that's just notably one thing that's missing here. If you're given that and you need to cite to the documents, you would want to make sure that every single sentence here is cited to a document. So here we have Kenny Powers is a 10-year-old boy. He was walking with his friend Wade LeBlanc to meet at a park on July 5th, 2023. So that would come from a document. It comes from a deposition. Hey, we interviewed Kenny, we interviewed his mom, we interviewed Wade, and that's what they told us. Then you would just cite to that deposition. But for our purposes, we didn't need to do that in this assignment, but something to look out for. The only other important thing I want to say about the statement of facts is that, remember, we didn't really talk much about our facts structurally until we got to this A section. And like I said before, your A section may be a lot longer than this. You may have multiple A's for multiple issues and things. So one thing you want to be certain of is go through here and look at all the facts that you used here. Make sure that every fact you use in your A section was mentioned in your statement of facts. So students often start writing things in their application section and they're bringing up different facts. Like here we have Kenny throwing sticks and lunging towards Dingo. Well, what often happens is they wrote their statement of facts before and they didn't really know what facts were going to be most important and what facts they were going to use. So maybe I completely forgot to mention in my statement of facts that they threw sticks at the dog. And now I'm using the fact that they threw sticks at the dog as a really important fact in my analysis. So I just want to make sure, just scan your application section for all the facts that you used and then go ahead and cross-reference your statement of facts and make sure that they're all in there that you initially told the reader. So in other words, the reader should not be learning any new facts after the statement of facts. And the last bit I want to talk about here is citations. So like I said, the statement of facts, you might need citations for that. We didn't need them here, but in that case, you're citing to the documents that you were given originally from your professor. But everyone will be citing to the sources that they used in their discussion section. So in law school, we use something called the Blue Book. If you haven't already been introduced to that, it's a book and a system for providing citations. But here are some important areas that you need to cite. So anytime you're writing a rule statement like this, right, we're telling the reader that these rules exist and that they're the basis for our analysis later. So anytime you write a rule, you need to tell us where that rule came from. We can't just be your opinion. And so you'll notice with synthesis, this is where students kind of get a little bit hung up. This rule was our synthesized rule. We kind of made it up. But why did we make it up? So you could cite to cases that stand for that concept. Or here, when I had that whole list of 4 cases in my outline, we could have cited to all 4 of them here and said, see this case, this case, this case, this case. So where do you need citations? Anytime you have a rule that came out of a case, you need to cite to that case and tell us where it came from. So that would come here, and then in our umbrella section, we have some rules. They're probably going to need to be cited. Your conclusion does not need to be cited. This is your work product. That's your opinion. Our rules, though, all came out of cases. So you'll notice every single sentence, there's a period, there's a citation. There's a period, there's a citation. There's a period, there's a citation. So every single rule statement that you make should have a citation after. And the same goes for every sentence in your E section. Remember, here we're talking about a case. We're doing a case illustration. So here we're talking about Robinson. The easier thing often about a case illustration, though, is that this whole paragraph is going to be about Robinson, right? So once we cite to Robinson once, we just continually cite to Robinson again. So here's another E section. Every single sentence here will be cited to Seaworth, and every single sentence of this paragraph will be cited to the Steele case. Now, once you get into your A section, generally, most professors say you don't need to cite within this section. So these are now your work product. So you're comparing things that you've already explained and cited to your own opinions, your own facts. Some professors would say, well, here we're talking about the victim in Robinson. So I want a citation there as well. But I'd say that's the minority of professors. But if you need that, just same concept. Every time you're talking about a case, just give us a citation after that. But for the most part, you only really need citations. As far as your CREAC goes, you're only going to need to cite your R section
and your E-sections. All right, so that's pretty much it here. I don't want to do too much more on citations. This video is already going to be very long. You should have a separate class on how to do citations and how to use the Blue Book. But that about does it for how to write a law school memo. Obviously, it can get much more complicated and involved than the simple memo that we wrote here, but we went through all the basics of reading the prompt, doing some research, organizing our research, outlining our arguments, and understanding the CREAC format, and then drafting those different sections that we're ultimately going to need in our paper. Remember that you can get all the documents associated with this project at my website, jdlogic.org. It's all free. You can download it, go along with this video, and hopefully that'll help you see how it all comes together. Thank you for watching, and have a nice day.